Hey everybody, we're back in the shanty. I know it's not our normal day, but there's a couple things going on that I thought you might want to know about. Nothing you have to do anything about right away, nothing really urgent, but some news that many of you have been asking about. And so I'm going to give you a couple of updates. Update number one has to do with the FLSA Salary Level Test. That is the second part of which is set to go into effect on January 1 of 2025. And you'll recall the first part went in back in, I want to say July, but I can't remember. It was a while ago. Then we've got that second step, which is a pretty sizable one coming in January 1 of 2025 that's going to affect a bunch of you. And by the way, no, the election does not change that. It is a rule. It has gone through the notice and comment period, and it has been published in the Federal Register, so it's a final rule. The election may change one thing that's going to happen about that, and I'll talk about that in a minute. And then the third thing about that rule that was troubling to a lot of people was kind of this automatic kicker, where every couple of years, based on inflation and the consumer price index and whatever formula they used in that, the rate was going to potentially go up again automatically. That case, as you know, is being litigated. And as you know, the Fifth Circuit recently decided that a salary basis test was legal based on the 2019 rule. And what the Fifth Circuit did in that case was they kind of outlined the way that the district court in this case could either invalidate the rule if that's what they wanted to do, or validate the rule if that's what they wanted to do. Now, you might remember that I told you back when the district court granted summary judgment to the state of Texas as an employer only, not summary judgment, I'm sorry, they granted an injunction to the state of Texas as an employer only, that I thought the court tipped its hat and explained that it thought the rule was invalid. But we don't know. And I'm certainly not going to make a prediction, because every time I've made a prediction, seems like in the last 12 years, I've been completely wrong, flat wrong, not going to do it again. And you'll be happy to know that I will not be going to the track anytime soon to place any bets. And I'm certainly not playing the lottery. So that oral argument on the motion for summary judgment happens today, if this is Friday. It happens Friday the 8th. What that means is we're not going to have a decision today, but the oral argument is going to occur. And hopefully we will have a decision very quickly after that from the court, where the court either validates the rule, and we know we have to make those changes come January 1 to some people that are in the gap, or the court invalidates the rule. And we don't have to make those changes January 1 for the people that are in the gap. Now, the election, what that does is it makes it pretty certain. Again, this is kind of a prediction. I wish, like I just said, I wasn't going to make these, but it makes it pretty certain that if the court invalidates the rule, there will not be an appeal from the Department of Labor. The Department of Labor will likely not appeal that, and they'll just let the rule go away, and they'll either publish a new rule under the new administration, or they won't publish any rule at all. They'll decide that the salary level test, as it's set right now, is currently high enough. So that's what's going on with that. Now, the big news for you folks is this. So I got an email this morning from one of you, one of my good clients, and the email said, with the change in the legislature in Michigan from democratically controlled to Republican controlled, can we expect changes to the Earned Sick Time Act? And my response was, maybe, but don't forget the governor is still a member of the Democratic Party, and changes don't mean there'll be changes, even if a bill is introduced. And I thought it was unlikely, and I think I said that. And again, I was wrong, because today, a bill was introduced in the Michigan legislature that makes some proposed changes to the Earned Sick Time Act. And there's two big ones. The first thing the thing does is it cleans up a bunch of the really iffy language in the statute. You've heard me say before that was a poorly drafted statute. I thought it was a poorly drafted statute. It wasn't drafted as a statute. It was an initiative or a referendum. I can't remember which it was. But it was going to go on the ballot because it was got enough signatures. And we went through the whole rigmarole with the appeal and everything else. Getting to the heart of it, we cleaned up some language in the statute. We didn't clean up. The legislature cleaned up some language in the statute. And the legislature moved some stuff around. Like they moved the 40-hour presumption for exempt people to a different place. And they moved the year definition of year, I think, to a different place. And none of that matters. Here's what matters for you. I gotta look at my phone because I didn't bring my computer home. How am I taping this, you ask? On my iPad. The first thing it does is it makes it clear that independent contractors are not covered by the ESTA. Independent contractors are not entitled to paid sick time under the statute. Now, I always thought that was true anyway. I thought the language was clear enough to exclude independent contractors. Independent contractors are not employees. They are independent contractors. But there's now an amendment proposed that would make it clear, and they do that by saying ESTA covers employees from whom you are required to deduct federal income taxes. And for independent contractors, you obviously don't deduct federal income taxes or any other taxes for that matter. But for employees, you do. So that's one change, proposed change in the statute that clarifies the statute. The second thing that it does is going to be really important to a lot of you, because a lot of you were hemming and hawing about front loading your paid sick time under your policy as opposed to accruing it. Many of you don't want to accrue. It's administratively burdensome to have to, accrue throughout the year. So you wanted to front load. And we took the position that you could front load because we thought it was better, more advantageous to the employee. And the statute allows you to do more. We were confirmed in that belief by the FAQs that the state posted, and I did a broadcast on that a while ago. And in those FAQs, the state said, because the statute doesn't say you can't front load, that means you can front load. Well, now with this amendment, it is clear that you can front load. In the paragraph that deals with accruing 1 hour for every 30 hours worked, there's now a proviso that says you have to accrue 1 hour for every 30 hours worked unless you front load at least 72 hours of paid sick time. In other words, you grant it all at the beginning of the year. And the other nice thing that the statute does, is the amendment does, I keep saying statute, that the proposed amendment does, is it makes it clear that if you front load at least 72 hours at the beginning of the year, that you are no longer required to allow carryover. Okay, so remember, under ESTA, you had to accrue 1 hour for every 30 hours worked, and anything that wasn't used had to be carried over to the next year. And that's all it said. So even when we were talking about front loading, we were saying you still were going to have to allow carryover. Now that never made any sense, because if I front load 72 hours at the beginning of the year and you don't use 10 hours of it, and then we get to the next year and I front load 72 hours, but 10 hours carried over, now you've got 82. You don't really have 82 because I only had to let you use 72 in the year. So that 10 hours was meaningless. This amendment, proposed amendment, clarifies that. Clarifies that if you front load, you don't have to do carryover anymore, and it solves that problem. Now, for those of you that were thinking about front loading anyway and have already drafted your policies to do that, that's great, and you're probably covered. But you might want to go into that policy now and deal with the carryover thing if you talk about allowing employees to carry over. Because again, if you front load, you don't have to carry over. Now, I say you might want to do that, but let's take it easy here just a minute. Remember, this is a bill proposed in the legislature. Remember back to your days when you were a kid? I'm just a bill. Yes, I'm only a bill. And I'm sitting here on Capitol Hill. I know you wanted to hear me sing. It's a bill. We don't know if it's going to get passed. We don't know if it's going to get marked up more. We don't know. It is a bill to amend the statute. And what we surely don't know is the governor going to sign it? All right? So, that's what we got going on. Now, that's pretty good news. If all of this goes through smoothly, those are two changes to the statute that are beneficial. At least the front-loading change of the statute is certainly beneficial. It gives you some clarity and allows you to do some things that you all wanted to do anyway. So that's great news. That's what we got going on. We'll keep an eye on what's going on in Texas, and we'll let you know when we hear anything. We'll keep an eye on what's going on in Lansing, and we'll let you know when we hear anything. Have a great day, a great weekend, and we'll see you next time.